Thank you for that, Senator. We're going to get right back into it, and so I'd like to reintroduce, and I've always wanted to say this, back to you, Colleen.
And I'll say to you, that took too much time. 6 o'clock rolls around the same time every day. Good afternoon again, everyone, and we hope you enjoyed your lunch. We're going to be talking now with a pretty distinguished panel of professionals that I'm going to introduce to you, starting with my immediate right, of course, Chief Justice Maureen O'Connor of the Supreme Court of Ohio. Yeah. You know, she is not allowed to comment on any pending cases, and I'm not supposed to ask her questions and say things about pending cases, but let's just say hypothetically, there was a Chief Justice who stood up to people who were trying to deny voters right when it comes to redistricting. Wouldn't you applaud that? Again, okay, that was just a hypothetical. Next, Judge Jeffrey Mackey. Oh, I thought I had them in order. I do not. But Judge Mackey with the FranklinCounty Probate Court. Camilla Taylor is with us. She's the Director of Constitutional Litigation for Lambda Legal. And to my far, far right, Raphael Davis-Williams, the Director of Equity and Inclusion for the ACLU. I'm going to begin with a very general and broad topic and ask each of you to comment, if you would. We are seeing a lot of how do I want to say this? We've politicized a lot of these issues. As a result of politicizing issues, we are seeing legislation that seems to be politically motivated and possibly making people who are in the LGBTQ community vulnerable. So I would like each of you just to give me a comment of where you think we are now, politically, legally, and culturally when it comes to these issues, just your general feeling about the tone of where we are now. And I'm going to start with you, Chief Justice.
Well, thank you very much for the opportunity to be here, the invitation. I appreciate it very much. I see a lot of people in the audience that I recognize, including some employees. So it's nice to see my employees here as well. And folks from the Bar Association, the Foundation, et cetera. I'm on a distinguished panel. I appreciate that. Where are we? What's being politicized and why? What isn't being politicized? Is the way I look at it. Everything is being politicized. Bail reform is being politicized. LGBTQ, education is being politicized, for gosh sakes. And why? Why is this happening? I think that's what we need to figure out. And you know why? Because it works. That's the problem, that over the last, I'm going to say 15 years, maybe, issues have come up for a political purpose that have no connection to politics, should not have any connection to politics, and they become politicized, and it motivates people because with that divisiveness, what has to accompany it? Misinformation has to accompany it. So they go hand in hand. The divisiveness, the misinformation, the politicalization, you can't have one without the other. And, the LGBTQ issues, community is, in the crosshairs when it comes to politicizing everything, why? Because it works. Because people are not informed. And so what's the challenge? The challenge is to get the right information out to people and have people understand. People have the misinformation debunked, and have members of all communities of support to do that, not just the LGBTQ community speaking for yourselves. You've got to have people like me and people like, Colleen and, all kinds of, folks to be out there, talking in terms, people with credibility in other issues need to step up and use that credibility, use that capital, political capital, to step up and, challenge and debunk and remind people that we're all human beings and we all deserve to live, pursuit of life, liberty, and the pursuit of happiness. And equality is part of that.
Thank you. Camilla, I'll ask you as well. From Lambda Legal, this is your life's work. What are you seeing as you look around Ohio and the nation when it comes to these issues being politicized?
Well, I join the Chief Justice in expressing gratitude for the opportunity to be here, and it's wonderful to see so many people here as well. I couldn't agree more with the Chief Justice's words. And those of us who remember the fight for the freedom to marry remember a time when state after state passed anti-gay constitutional amendments and laws targeting same-sex couples and their children for discrimination. And there are some colleagues here in the room, like Leanne Masucci, who worked together with Lambda Legal in order to help establish again and again. We had Ohio appellate courts clarify that these anti-gay constitutional amendments, for example, here in Ohio, did not preclude parents from the ability to establish legal relationships and custody with respect to their children. These were cynical, politically motivated attacks on the LGBT community with the assumption that they would bring a certain portion of the electorate out to vote if they were put on the ballot. And now we're seeing it again. We're seeing a new generation of these laws, except even more cruelly. They are targeting children often. They're targeting transgender children in many, many different ways, including bills that are proposed here. Bills that would prevent parents and children from being able to get the health care that their doctors determine is medically necessary for them. Some of these bills would make it a felony for parents or for doctors to provide such health care to children, even though the consensus of the medical community is that this health care is absolutely essential for them. We're seeing bills that would target trans children and prevent them from playing sports, playing on athletic teams. And here in Ohio, just last term, we saw a measure that was sneaked into a budget bill at the very last minute that invites discrimination by healthcare providers in a particularly cruel way. It says that any healthcare provider that even has a moral objection to providing healthcare for a patient doesn't need to participate in providing that care, doesn't even need to take records, doesn't need to provide prescriptions, does not need to tell anyone that they're refusing to provide that care, and can veto another healthcare provider at that same institution from stepping in and providing the care that they refuse to provide themselves. The patient simply has a right to seek health care at another institution, to be told that. This will result in people being hurt, and some will even die as a result of being refused medically necessary health care. This measure says that a healthcare provider cannot be made liable for a refusal to provide care in this way. In our view, it violates all sorts of Ohio and federal constitutional guarantees, including the single subject rule, the Establishment Clause, and of course it will result in discrimination. So there are a number of things that we're deeply concerned about, and the courts again and again have been stepping in to hold some of the worst measures at bay. They've done so historically. They're doing so in Texas and in other places where these healthcare bans have gone into effect. It's yet another time when lawyers play a particularly important role.
And with that, we're going to move on to Judge Mackey, who is seeing this more on the local level, but certainly throughout your career, you've seen some big changes when it surrounds the people politicizing these issues.
Yes, thank you, Colleen, and thank you to the Ohio State Bar Foundation for having this. I'm flabbergasted by the attendance we have here, so this is awesome. The politicization of these issues certainly has a personal impact on me, as well as my role as a judge. And as a judge, I'm not allowed to discuss political issues and things of that sort. I could be disciplined. We don't want that happening. The Chief Justice here, she does not want to see me come to her court. I don't want to get anybody to squeal on me.
She's taking notes.
She's taking notes. This is all being recorded. So I'll kind of talk more in generalities. But in terms of elective politics, because that's part of what we're referring to, I was a probate lawyer here in Franklin County for 38 years before I ran for probate judge. I was elected 2 years ago. I was the first openly LGBT judge elected in Franklin County, a county of 1.4 million people. In my campaign, in my election, that issue was not raised at all. Certainly in Franklin County, that's an election issue that really nobody seems to care about. I don't know that that's the case in all 88 counties. So that was not an issue for me personally in my campaign. When I went on the bench a couple years ago, I had a perspective of my 38 years in probate practice, and most of you probably don't know much about the probate court. Probate courts are courts of specific jurisdiction. We don't hear criminal cases. We don't hear money disputes, lawsuits. We do certain things, estates, guardianships, adoptions, name changes, marriage licenses, psychiatric involuntary commitments. And it's just weird how a kind of a boring court like the probate court seemed to have been kind of a flashpoint for a lot of these LGBT issues over the years. Who would have thought? And some of the issues that come to mind, and I'll mention them kind of in chronological order, name changes, and I'm not going to get into the details of all of these, but name changes. You had a same-sex couple before marriage equality, and they wanted to have the same last name. Who would have thought that was a big deal? Name changes. Adoptions. Well, adoptions are a big deal. They're a big deal for a lot of people, and for same-sex couples before marriage equality, the laws in Ohio and most other states were pretty restrictive on allowing same-sex couples who are not married, or even if they were married legally in a different state, it wasn't recognized in Ohio because of Issue 1, our constitutional amendment. So adoption, who knew that was such a political issue? And then, of course, we had the big, the big 400-pound gorilla, or whatever the expression is, that's marriage equality. So marriage equality was a big issue because the probate court is where you get your marriage license. So before the Obergefell decision in, I believe that was 2015, we used to have, the residents of Franklin County used to come down to the probate court on Valentine's Day, and they would have kind of a protest. They would go to the marriage counter and they'd try to get marriage licenses, and they had to be told, I'm sorry, you can't get a marriage license. And so that was kind of an annual protest in a good way over marriages, marriage equality. Well, that was resolved in 2015, which resolved some of these other issues, such as the adoption issue. Now that you have married couples who are legally married, they have different rights than they used to have. All right, everything seemed well and good, Now we have this other issue which has surfaced in the political arena, and that's the issue regarding the trans community, the transgender community. Gender marker changes on your birth certificates, I can certainly talk about that in more detail later, and under Lambda Legal and ACLU were the lead plaintiffs in the federal lawsuit that put Ohio in the position where they had to allow applicants to change their gender marker. And in case you didn't know, there are 50 states. I know you know there's 50 states. But did you know, this is not a test, Ohio was the 49th state to allow this. So I was like, we're number 49, yeah! I think only Tennessee prohibits it now, and I'm not sure where they're at. But it took Ohio a long time to get to that point, and they were forced to do it by the federal court. So the gender marker change and some of the politicization of the trans community is kind of where we seem to be heading next. Fortunately, the probate courts, we are not there advocating anything in a political sense. We are there hearing cases on a case-by-case basis as they come in. So we see this as it impacts individual people. Married couples now who want to do their adoption, somebody in the trans community that wants to change their gender marker. And these are all happening, certainly in my court in a very routine way and in a very fair and equal way. And I'm really proud to say that the Franklin County Probate Court is, as far as I'm concerned, the leading probate court in Ohio, and we've taken a kind of a lead role on a lot of these issues. I'm not sure I've convinced all of my other 88 county probate judges to do what we're doing, but I think we are having some impact. So thank you.
Thank you.
Okay.
And Raphael, you are with the ACLU. You, as well as Lambda Legal, you've been at the forefront of these legal fights, but you continue to see as well that everything's politicized, right?
Absolutely. And I will start also by thanking Colleen and the State Bar Association for this event and for the invitation. And it is, I'll take those as you presented them, politically, legally, and culturally. And I'll take them in reverse order because culturally, I will say, look at this room. This room screams what's going on culturally, because there was a time not very long ago, I've been an Ohio resident for about 14 going on 15 years, and when my husband and I moved here, Ohio had the second worst DOMA law in the country. The opportunity to have a meeting like this, with the rainbow flag and LGBTQ plastered all over the State House was unthinkable. And that was just a very short period of time. So culturally, that's where we are. And it is not just the individuals who are in this room. Each of you know someone, have friends, have family, have neighbors, have church members, and all those things across all 88 counties. And so where we are culturally, that's what's moving us. What's happening, though, from the legal part and the politicization part are connected, because what is happening politically, in my opinion, we have, there are people who see the writing on the wall. They see a meeting like this. They see a conference where people can be out and be themselves. They see parents who are supporting their transgender children instead of kicking them out of the house. They see people who are wrapping their arms around LGBTQ people, and that scares them because that's not where they are. And so what I say is happening politically, we are seeing the death throes of a segment of our population who doesn't want to see this. And all this is an affirmation of how much and how far we've come as a society, where it doesn't matter, why do I care with whom you sleep? Why do I care how you are raising your child? This idea, from a political standpoint, that it's hypocritical is that's one word that comes to mind. Several do, and I have to remember my audience here. But it makes absolutely no sense on one hand to say, government hands off, we don't want to do anything like this. But we are down to the point where we're going to tell a parent how what they can say to their child and the health care they can provide to their child. That's ludicrous. So from that perspective, and it goes back to the legal part where we have been at the forefront of a lot of the battles in the courts. But because of the politicization of some of these issues, now we have to be careful about where we are with the courts, because the courts are changing. In fact, the federal court system is not what it was when I was litigating as a civil rights attorney. And now we have to make sure that we are looking to state courts. But what it really says, what it really means is that each of the individuals in this room, you have an obligation, you have a responsibility to go out and make sure that you are making sure that those people who think like you, who look like you, who love like you, are in a position to make sure that they are casting votes that are going to put people in who are going to benefit, who are going to work on your behalf on what's beneficial for you and your family. That starts with the Ohio Fairness Act. There's a ton of things that we could go through with that, but the politicization comes from the fact that the culture has not just changed, and we can't roll this back. We can't put this as the opportunity to revert. We are not going to go back to this supposed idyllic time where gay people are in the closet, where transgender people don't exist. That's just not going to happen. So we are moving forward, and that's what's driving the politicization, in my opinion.
I think I agree with you. In fact, I do agree with you. But before we talk about some of the cases that are pending now and some of the statutes, we should talk a little bit about cases that got us to where we are. I know not everyone in this room is an attorney. There were two major pieces of legislation. One was called two major cases, Bostock, Masterpiece, Cake Shop. Even if you weren't an attorney, you probably heard about that. The baker who did not want to make a cake for a same-sex couple. And then there was the Harris Funeral Homes case versus the EEOC. In that case, it was a transgender employee who transitioned while they were employed there, and once they went from male to female, they lost their job. So these two cases, I'll start with you on this, Camilla. I know that Lambda Legal took some strong positions on cases like this. How important is it when what seems to be a simple employment case gets to a high court and changes the narrative about the way employers can treat people of transgender or gay?
Well, thank you. This was a tremendously important case, Bostock, and the issue was whether Title VII of the Civil Rights Act of 1964, which prohibits discrimination in employment on the basis of sex, among other things, whether that must be read to prohibit discrimination based on sexual orientation and gender identity as well, because those are both forms of sex discrimination. And it was ultimately a very conservative argument that we made to to various courts around the country for decades, and eventually some federal appeals courts began to agree, and then the Supreme Court did just a year ago about. And the argument was this: if you are a gay person and you are discriminated against because you are a man and you are in a relationship with another man, then you are being discriminated against because of your sex, because but for your own sex as a man, you would not be experiencing that discrimination. Similarly, if a transgender person is discriminated against because they announce to their employer that they henceforth would like to be referred to as a different sex, and that's their identity, and that's who they are being discriminated against because of their sex as well. But for their sex, they would not experience that. So the Supreme Court ruled that these are forms of sex discrimination, and by consequence, they are already prohibited as a matter of federal law. This was a particularly wonderful result. A lot of people had argued that the Supreme Court should not rule this way. They'd argued that the legislature in 1964, when it added sex to the Civil Rights Act, couldn't possibly have meant to include trans and gay people as part of the protection of that statute. But it was a very textualist answer that they got, which was, well, if the statute says what it says, and there can be unanticipated consequences. We don't look behind the statute to legislative history when the statutory language is clear. Title VII is just one of the many federal laws that prohibits sex discrimination. There are federal laws that prohibit discrimination in housing based on sex or credit, and in the provision of health care. And Title VII usually has been interpreted in the same manner as those other prohibitions on sex discrimination. Title IX is another example of a federal law prohibiting sex discrimination. So this understanding of the law in Bostock, this interpretation from the Supreme Court, is going to have a huge impact, not just in federal employment, but in other contexts. And I just want to say very briefly, it does not, however, supplant the need for state prohibitions that are explicit, based on sexual orientation and gender identity, and that work has to continue. The Equality Act remains extremely important too, because it would make clear that discrimination in public accommodations and in other contexts is prohibited too.
That brings me to a question for you, Chief Justice, because I'm sure you follow cases like this. Everyone was following that case when it got to the high court. How soon is it when you realize, okay, now changes have to be made in Ohio? Procedurally, how does this work when it gets to the state courts?
Well, let's think about how you approach cases in court, specifically probate court, when some of the results are written in stone by case law. The gender marker, name changes, same-sex marriage, those are all, as Judge said, probate issues. And so the Supreme Court provides forms that the courts use, and prior to the decisions, they had designation of that would indicate male-female is what was anticipated by the use of the forms. The day the ruling came out on same-sex marriage, I ordered that the forms be changed to reflect that, and they were. And those are the Supreme Court forms, and under the rules of superintendents, those forms those are the, when I say the very minimum that you can have in one of your forms. Probate courts can add things to them if they want to do so, but they have to use the designations that the probate court, or excuse me, that the Supreme Court. So it's imperative that a state court, a Supreme Court, would do what I consider the nuts and bolts of the implementation of the consequences of those decisions, so that people can go up to get a marriage license, and they don't have husband and wife. They don't have designations that are, I guess, gender specific. For example, they pay attention, and in many ways they honor the equality of all people by not having those designations on those forms. So it was important. It was important to me that we changed forms as soon as those cases came out.
Are you sure you're a Republican?
I don't think I am anymore.
That was just between us kids, by the way. So Judge Mackey, of course, this changed so much for you. And we were speaking earlier, and what I found interesting is you said the probate judges around the state maybe are not embracing this. When you get into some of the outlying counties, the Supreme Court, as you said, they've made it for you. They give you these forms. They help you do your work. Is it easy? It's easier for you. Why isn't it easier for everyone else?
That's an excellent question.
Thank you.
We do have 88 counties, and we have at least 88 different probate judges.
Actually, there's 89 because there's 2 in Cuyahoga County.
That is true. So that's why I said at least. But we do have 88 counties. And this federal lawsuit, again, that was filed, the lead plaintiffs being Lambda Legal and the ACLU, this was the Ray versus McLeod case, federal court case decided by Judge Michael Watson, who used to be a judge here in Franklin County, who is a pretty conservative Republican. Mm-hmm. But he issued the ruling in the federal court that the Ohio Department of Health could not prohibit individuals seeking gender marker changes. And again, as I said, we were the 49th state to do that. The decision's fascinating. For those of the lawyers out here, you might want to read the decision, because Judge Watson's decision is, I think, very spectacular. He's pretty conservative, but he just struck down every argument that the state of Ohio made, and the state of Ohio did not appeal that decision. Therefore, the Department of Health was supposed to change their process to allow, in essence, transgender people to change their gender marker on the birth certificate. Okay, big deal. Who cares? Apparently some people do, but who cares? Then the Department of Health, for some reason, kicked this around for a long time and then said, you know what, we're not going to do that. We're going to let the probate judges deal with that. We didn't see that coming. Seemed fairly simple to us, and Franklin County and some of the other counties, the larger counties, Cuyahoga County, we came up with procedures to do this. It didn't seem to be that complicated. It's in a birth correction, so you're correcting your birth certificate, which can be corrected for a variety of reasons. Maybe your mother's maiden name was spelled incorrectly. There may be some very simple reasons, but we, considered a gender marker change to be a birth correction. Okay, federal court said we should be doing this. Probate judges were somewhat resistant, some of them. Supreme Court, thank you, Chief Justice. Supreme Court changed their standard probate forms. Sounds like something we should be using, standard probate forms, to say this is the process those applicants should use. It's the process some of the larger counties are already doing. It's not that complicated. But strangely enough, some of the counties, the judges are saying, well, we don't have any statutory authority for this. We want the legislature to change the statute. Well, that's never going to happen. So I was invited to speak to the Ohio Probate Judges Association meeting a couple months ago, which was a great honor, because being a fairly new judge to speak to that group was an honor. And I spoke on the topic of the gender marker changes, and basically was expressing to these probate judges, this is not that hard. Here is how you do it. And not only did you have the federal court saying doing, you have the Ohio Supreme Court saying here is the way in which you do it. Seems like a done deal to me. I got rave reviews on my presentation, but when I talked to some of my colleagues afterwards, I said, do you think I changed any hearts and minds? And they said, no. So I'm not sure what they're doing. Some of these judges who are reluctant, again, they're all fine people. I said, well, how many of these cases have you had? And they said, well, I haven't had any yet, or I had one. And I said, well, we get about 10 a week in Franklin County. We run them through in a very simple process, simple and fair process. We don't require hearings. We don't require things that some other courts may require. We have not had any problem with this. It is a process that, and again, I've had some other judges say, why do you care so much? Why do you care? Saying to the judges who won't do this, why is this so personal to you? I do not have an answer for that. Only you can look into your own hearts and come up with why you think that would be that some judges would be refusing to do this. As a slight side note to that, in Ohio you can change your gender, but only to either male or female. We do not have non-binary as a category, or none or other. There are a minority of states that do allow maybe like non-binary, and strangely enough, I think it was it Oklahoma, I think, that allowed people to choose other options, including non-binary. And a law, I think, may have just been passed in, I believe it was Oklahoma, to prohibit that. Now, again, why do they care? Why is this so important to those legislators in Oklahoma? I do not know. But in Ohio, you only have two options, male or female, and that's how it is in most states. But I think it shows the politicization of some of these issues. Any way they can turn this into a more political issue that perhaps they can use in the elections, they will do so. Fortunately, we have not had that particular issue in Ohio. But this case, the Ray versus McLeod case, is a fascinating example of how a clerical change could have a huge impact for some individuals. This is not something people do lightly. In my research for my talk to the probate judges, I was kind of curious, well, how many transgender people are there out there? I don't really know. It's a hard thing to poll, but seems like the best guess is, not guess, based on surveys and whatnot, is perhaps slightly more than 1% of the population is transgender. Well, there's 11 million people in Ohio. That's 110,000 people in Ohio that perhaps identify as transgender? Well, that's a pretty significant number. 1.4 million people in Franklin County, that's like 14,000 people here. If those individuals are allowed to change their gender marker because that's how they identify, why would I, as a probate judge, say, no, you cannot do that? So it's a clerical change, if you want to think of it that way. Probate court forms, standard probate court forms for change, but it has huge impact to those individuals who now have a better sense of themselves. And so I'm proud that we've been able to, here in Ohio, through the efforts of the Supreme Court and some of the probate courts, have made that impact on that group of individuals.
It's life validating for a
Yes.
lot of people,
Yes.
What you're calling a clerical change. And Raphael, I see you want to comment on this. And I also, after your comment, I want you to comment on some of the pending legislation here in Ohio, including House Bill 616. But weigh in on this first.
Sure. It is, I just wanted to say, it's more, respect to Judge Mackey, it is more than clerical because the clients that we had were trying to, one individual I remember specifically needed to get, was a truck driver and needed to get updated driver's license. And where you go when you are getting your driver's license, you need another form of identification. Well, you have one form of identification that says male and one form of identification that says female, and then they say, well, what does your birth certificate say? And that puts people's lives in danger because that individual had to, when trying to go to different truck stops and these things. That's how they make these decisions based on that. And that's someone's life that's in danger there. So it is a simple clerical change, but it actually affects people's lives. People are in danger. House Bill 616. The idea that we are that transgender individuals have again, it's one of those questions where you have to say, what is the motivating factor here? Are we really what are we really concerned with when we are making it difficult for kids, they are kids, to play in sports, to participate in activities that every other high school person did, as their authentic selves. That's really where it comes in. And I will tell you, I did not come out until I was 27 years old. I spent the bulk of the first part of my life petrified that anyone was going to find out, and that's from my family on over, would find out anything that was negative about me. And here we have individual families who are embracing their children, saying, here, be on the swim team, be on the track team, or do these things, and we're going to legislate against them to tell them they cannot do this simply because of who they are. We were talking earlier. There is no joke. There is no question, I should say. It is almost an insurmountable hill to climb here in the Ohio legislature, as it is currently constructed. But we have a hypothetical Supreme Court justice that is doing everything to make sure that we change the way that these districts are drawn, so that individuals are able to get representatives who are there, who are concerned about the well-being of their constituents and not their personal agendas. At the ACLU, we protect and expand civil liberties, civil rights, and racial justice. That's what we do. We don't say based on what you look like. We don't say based on where you come from, who you love, and all of those things. And that, when you get down to it is pure, unadulterated discrimination against someone simply for being. And that's where the problem comes.
And I see you, Camilla, is nodding as well, because these issues. This is an Ohio issue right now, and it's just a proposal, House Bill 616, but it's a proposal that one imagines will get a lot of support in these buildings, that there will be a lot of people who say, yeah, that we need to legislate this, from a legislature that has not followed a Supreme Court order on school funding for 2 decades. So when you look at this, I'm not allowed to be political, so don't. But when you look at this, you must think, okay, what can we do in Ohio to change this narrative and the path that this bill it might be going down?
Well, I have a little bit of a story, I think, that's related to this, because Ohio is not the first state to consider passing a law that targets transgender children for preventing them from joining athletic teams. West Virginia passed one, and we filed a lawsuit on behalf of Becky Pepper Jackson, a little blonde, blue-eyed girl who was also transgender. She's 11 years old. She wanted to play on the cross country and the track team of her middle school, and we sued on her behalf. We succeeded in getting a preliminary injunction preventing the law from taking effect as to her, and in discovery, with the state of West Virginia, we discovered that state officials were unaware of any other transgender athlete, middle school or high school, in the state at all. This law affected only Becky Pepper Jackson, according to the state officials of West Virginia. And Becky, who came in something like 123 out of 150 kids in her last track meet, is not preventing any other girl from participating on this team. She's not hurting anyone. She formerly participated in the cheer team. She simply wants to have the experience of having teammates, of competing. And the cruelty of passing a law that impacts in West Virginia precisely one person, to exclude them and to make them feel different and an outsider, and as though they should be ashamed and that there's something wrong with them, is just heartless. And so I encourage Ohioans to think about what the consequences would be for kids in this state, and just how needlessly cruel this sort of legislation is. It protects no one, it just hurts.
One of the things that I know personally, because I have grandchildren, is they play on teams that have both genders on the team, boys and girls. My grandson plays hockey. His teammates are girls, and quite frankly, they're better than he is. He's not going to watch this. But so I don't understand the justification when we have equality now voluntarily in so many communities with so many different sports. And I mean hockey, baseball, soccer, you know, and I don't get it.
That brings to mind Justice O'Connor. I've been interviewing people who are on the ballot, including justices, and some of them describe themselves as a textualist or as a strict, they strictly follow the statutory language, they're language interpreters. But when you are getting cases that involve people, how difficult is it for you, for other members of the judiciary, to look strictly at the law as legislators wrote it against your feelings of what the impact will be on the plaintiff or the defendant in the case, what it does to people?
I think you can imagine what what the outcome is going to be, but as judges, you're supposed to just apply the law as written, and the consequences are not your concern. That's hard for somebody like me who's never seen a problem I don't want to solve for somebody, and that's why I became a public servant in order to serve the public. There have been times when I've been accused of overstepping the limits of the legislation or the directive or whatever is being. But I can't say that I've got a philosophy that I'm going to always look behind and to the intent of the law, and that's going to be where I'm going to go, because that's not it. I mean, I've certainly made decisions that were gut-wrenching that I had to make because that's the way the law was written. Whether I liked it or not. A lot of times in those decisions, I added the admonition to the legislature, or maybe the request, please change this law because this is a consequence that you couldn't possibly have, intended to have. So I would definitely not consider myself a textualist or an originalist or, any of the other badges that people like to wear. I think sometimes that approach to the law becomes robotic. And I often say, why don't we just have computers and save all the money and for the benefits and the salaries and, we just have computers decide these cases. I say that jokingly, but so I don't believe in that kind of boxing yourself in as a judge into those kind of cubicles. Even Scalia, who is the champion of the originalist, etc. Somebody asked him a question about it, but he gave him a hypothetical and said, how would you look at that, given, I really should have a better foundation for what I'm telling you, but it actually, somebody asked him, under these circumstances, how would you apply your originalist theory to, the interpretation of law? He said, well, I may be a originalist, but I'm not crazy. In other words, I wouldn't use my originalist in order to analyze this problem. So I think that gives judges like me a lot of encouragement that you see it you understand what the textualists are saying, the originalists are saying, but I don't abide by it. I mean, I don't embrace it for myself.
Judge Mackey, you were the first openly gay, I believe, judge on the Franklin County Court. How important is it to have representation of the LGBTQ community, not just in the judiciary, but in elected office? How important is it for maybe people to step up who say, I want things to change, will run for office? You know, from your perspective, how important is that?
This answer might kind of shock you, but I'd say I don't think it's really that important because it was not an issue in my election. Since I was elected, there have been several more LGBT judges elected in Franklin County. I didn't open the floodgate. They're qualified people. They got elected on their qualifications, not on their sexual orientation. I think that would be the case with me. Since we don't set policy, my sexual orientation in theory is irrelevant to my responsibilities as a judge. Might be different for a legislator. They're making policies, and some of them, as we've discussed, have a basis that maybe we wouldn't agree with, but people might want to elect that legislator because they have the same philosophy on these different issues. I don't think people necessarily elect judges on that basis. We can't run saying, I will rule this way in this type of a case. We're prohibited from doing that. So I think in a judicial setting, certainly here in Ohio, the answer is no. I mean, am I a role model? I would say, oh, heaven forbid, I don't really think I'm a role model, but maybe I am. I know a lot of people in the LGBT community were very excited about my election. It was, it was kind of a big issue of discussion in that community, but not beyond my community. I ran against a sitting incumbent who'd been on the bench for 10 years, who was very well liked. He spent about 10 times more money than I did in the election. And I won by 8 points. So I won a substantially large victory, I think, based on other reasons other than my orientation. So I don't know if that answered the question or not.
I think it does. And Raphael, I saw you nodding your head. I think that from the perspective, he's right, he's in the judiciary. Until this year, judges would run without even an R or D behind their name in the general election. We weren't supposed to know their political affiliation or what they might rule because of their background. But in the legislature, that's a different story, isn't it?
Absolutely it is, and not just in the legislature, but beyond, in the corporate world, in education, in so many different areas. We've entered into this space of DEI, which is essentially my job, and there are so many different acronyms. We have JEDI and all these other great things. At the ACLU, we say equity, diversity, inclusion, and belonging. And it is at the belonging that all of this, it's the intersection of belonging where all of this comes together. And you can't have belonging if you don't feel, well, let me back up and say belonging is the idea that you fit in, that you belong where you are. So as a transgender person, whether you're on the judiciary or you're working at the local grocery store, if there's no one else who looks like you, who acts like you, who loves like you, who has anything, you don't feel like you are able to belong. And that's where it becomes important. And the legislature specifically, just to the point that there was only one individual in West Virginia affected by that particular law, that's where you are. If you are standing in the legislature and you have an uncle, a cousin, a sister, a brother, someone, and I hate to really go there because it shouldn't take that close of a familial tie to have the humanity to want someone to simply feel like they are a part of the community that they are living in. So yeah, it is extremely important as these particular laws are coming down because this law in Florida, which is utterly ridiculous. I won't get us too far afield, but with the CRT things, all of these different things they just don't even make sense, and it is an indication of a lack of exposure to the rest of the world. If you've lived in a bubble and you believe that that is the only way that is allowable to exist, then that becomes a problem. And that's what we are. We are focused on belonging. All of the others, we need them. We need equity, we need diversity, we need inclusion. But we need people to feel as though they belong, because once they feel like they belong, then they are able to bring their full, authentic personality themselves to whatever it is they're doing. And that just elevates everyone. Everyone is then operating at their highest level.
You know, I have a friend that some of you know who are from Central Ohio, Gail Hogan, who also used to be an anchor here. Her son works for that show, Chicago Hospital, and he got his first writing credit and wrote one of the scripts, and I interviewed him about it, and he's very nice, young, and he identifies as queer. And I said, you know, what's your ultimate goal? And he said, I just want to see a show where the gay character can be a lead and not be the ridiculous sidekick, where the gay character is accepted as having romance and having drama just the way the other characters on the show do. And as you talked about that acceptance, the reality is the things that we're talking about today, the reason they have been politicized is, as Chief Justice pointed out, it's popular. Mm-hmm. There are people out there in our state, our neighbors, who are agreeing and nodding their heads to critical race theory, transgender legislation. So how do we, Camilla, what do we do, or what should be done to really change? You're also almost asking people in parts of this state to change their thought process. Politicians are doing this because it's getting them votes, right?
Well, I was struck by something Raphael said a little bit earlier about the courage that it takes sometimes to come out. And so many LGBT people over the last couple of decades have exhibited courage in coming out and in living authentically and bravely and being who they are. And we've gotten to a point when I think it's very difficult for Americans to say, I don't know any gay people. And that serves as some measure of protection. Of course, there will still be assaults, and there will still be things that we'll need to roll back, and there will still be times we'll need to stand up and say that's not right. But the legislation that we are seeing right now is targeting the most vulnerable members of our community, those who vitally need gender-affirming health care, transgender kids. And it's doing that, I think, because our society has yet to be introduced to transgender people and to get to know them in the same way that it has learned to know and love gay people over the last couple of decades. And once we get to a point where society understands that these are members of our community, they're our neighbors, our family members, our friends, it becomes very difficult to put that genie back in the bottle, and it becomes very difficult to target this community in the same way. So I am optimistic that we will get there. But I think that the courts and the legal profession will have a lot of work to do. We need to hold the breach until we get there. We've got a big role to play in protecting these most vulnerable people until our society changes.
Well, I'm old enough that knowing someone who was gay when I was in high school was, you know, it was still shocking. Not only am I old enough, I'm Catholic enough that it was still, you know, and people didn't acknowledge it, people didn't talk about it, so we certainly have leaps and bounds. But I will ask you this, Chief Justice, does it look to you, as we see the legislation that's being introduced and accepted and promoted around the country, are we regressing?
I hope that that's not what this means, and I hope that, like, you know, I want to say that we have this legislation that's been introduced in Ohio, just like some other legislation that I think is divisive, that is now in committee in the legislature, and it hasn't gotten out of committee. And I'm optimistic, maybe foolishly so, that it's just being introduced as a placeholder, as a thing that the legislature or the people that signed on to it, they can say, see, constituents, I've introduced this, I've supported it, and I've done my part. And now, if it doesn't get passed, that's not my doing. I hope that that's, what we might be looking at. Although Florida is, an arena
Crazy?
that scares you. What's that? Yeah, Florida is I don't know. Anyway, so I think that, but there's some undeniable, written in stone, progress that allows for a certain freedom amongst the LGBTQ community, the right, the right to marry, the right to adopt, those are sort of things, which, are monumental. I used to, work in probate court as a magistrate for 9 years before I was a common pleas court judge, and I was the only, there were two magistrates in Summit County that would do name changes for, individuals that would come in and want their names changed because of their sexual orientation or identity. And, now it's standard operating procedure. That's not a big deal to change the name. Now, gender marker, as the judge said, it's a checker board on the 88 counties on how that's being administered. And we all know that it's going to have to be in the trial level, then go up to the appellate level. When there's a conflict in the appellate districts, it'll go up to the Supreme Court and they'll make a decision. That'll be long after I'm gone. But it'll be, if it takes that, then it will take that, because that's what a lot of changes happen. The fundamentals, I think, are people are scared of change. There's so many people that are scared of change, and then they have an outsized voice. They're scared of change because they don't want to discuss the topics in many instances. They don't want to have to explain to children, or, they don't want their children exposed, or how am I going to talk to them about, transgendered people? How am I going to talk to them about gay people? I don't want them to know those things. I think that is part of the problem that we have here. And just the disquieting effect of that kind of change in their lives. So what do you do about it? You have to, whether we're progressing or regressing or whatever, it's going to take changing the hearts and minds of people. You can legislate all you want and, do that tough fight, go through the courts, and that takes time. But again, getting out there and changing the hearts and minds of people and getting to the ballot box is what I think is how society actually changes. And that's what is critically important. Not just members of your community voting, but friends and family members and even strangers that you approach and encourage, and with just one good reason. You just need to give them one good reason why they should vote. And it just might be some issue that you have in common and not even your issue. And that's what I think it takes to show, that to me is progress. If we could get more voter participation, I really think that that's progress.
It's not just participation, though. It has to be participation in a way that they're advancing someone who agrees with their ideals.
Oh.
And I'm not sure people pay that close of attention. I always think we're doing all these stories about these issues and these candidates and these justices and how they're acting, and yet, people stop me and talk in the grocery store, and they'll have no idea on this story that we've done 100 stories on, because they really aren't as engaged as those of us who are out here think that they might be. So I know that Lambda Legal and the ACLU, you really try to fight for specific issues that you think are going to drive the system in the direction that you think is healthy for it to go. So how do those cases come to you? I'll start with you, Raphael. How do you decide this is the case that we are going to plant our flag and really fight to make change?
For us, it's very simple. The Constitution is our client, and that is where we start. And from there, we will then look at where is impact? How are we moving the ball? How are we educating the public on this particular issue? And that becomes a big part of what we do. Unfortunately, we get, our intake department is what you might imagine our intake department looks like. We have people reaching out to us, for a variety of different reasons, but what we usually do is sue the government. That's where the action happens, because that's where the civil liberties lie. That's where the civil rights are. That's where you can find justice. And so those are the cases the cases that come to us. We don't take what we call private or individual cases. I was a civil rights attorney for almost a decade doing employment law and housing law. And so when individuals would come to me with an issue that they were discriminated against based on their race or something along those lines, I took those cases. But the ACLU, what we generally go after, we go after those cases, or we look at those cases, and it's a flip for us. Where as a private attorney, clients come to you. When we see an issue that's there, we go out and look for the clients that can help advance that particular issue. And one of the things we're doing now, and it's not even a shameless plug, we are embarking upon something called a listening tour. In the coming months, you're going to hear a lot about that. And part of what it is, we the ACLU recognizes our origins. We are a 102-year-old organization, and primarily been a white male run organization for most of that time. But we recognize, and the cases that we've taken, the issues that we've taken on, have all been good. And it's the rare, one of the things I will pat ourselves on the back for. We have done really good work, but what we recognize we haven't done is go to the people who are impacted the most and find out from them what is the issue that's percolating for them. And then that's where we're going. That's our new phase. So we're going to be talking to those impacted people more frequently, and then we're going to elevate issues from that point. But that's the cases. What we do is we see where the problem is. We see the Ohio Fairness Act has been introduced in this building for 20 years now, I believe. I think we're at year 20, and it still hasn't passed. Those are the things that we look to when we know that there is an issue there that will serve the larger community. That's where we go. That's where we go when we're looking for cases.
And Camilla, I know Lambda Legal has a different set of priorities. Why don't you explain how your cases come to you? You talked about representing a single girl in the state of West Virginia, but you have really broad reach, don't you?
Yes, we're a national organization. We love to partner with the Ohio affiliate of the ACLU, with whom we have a wonderful relationship, and we make lots of good trouble together quite frequently. But our mission is to advocate on behalf of LGBT people and people living with HIV. And we do what's called impact litigation. So just as Raphael was describing, we bring only those cases that are designed to make an affirmative change in the law. But we partner with members of the private bar. We have a very large cooperating attorney network. So if there's an enforcement case, so it's clear that someone has experienced some terrible discrimination and there's a remedy for that, we'd love to refer those cases out to people who are in our network and would like to take those cases. And so we'd love it if there are folks here who'd be willing to be part of our cooperating attorney network, if they could sign up and join us. We also work closely with members of the Cooperating Attorney Network, including my friend Leanne here, to do impact litigation cases together. So we need pro bono co-counsel when we go out and create good trouble. And that's also a wonderful opportunity to work together. Finally, we are a 501c3 organization, so we do litigation and we do public education. But a lot of the wonderful work that we've heard described as necessary here in order to change hearts and minds is being done by partners like Equality Ohio, with Alana Yoakum sitting right here. And that essential work has to happen before hateful legislation is stopped and before we can advance with respect to civil rights protections under state law. And then also, I see partners here who do the safety net healthcare provider work, like Equitas. There are so many different ways to protect the most vulnerable members of the LGBT community. And it is important for all of us to work together, because often when those members of the community are in the crosshairs and they're under attack, we can all have a combined way of speaking up and sometimes challenging in court when those most vulnerable members are under attack.
But it makes me wonder if how data is being collected on LGBTQ cases. So I will ask the two members of the judiciary here, do we track LGBTQ issues and cases? And is there a database that is used or any kind of information that's used to inform judges about what directions are going, what the issues are that are arising? Is that something that's being tracked in Ohio?
I don't know of any tracking based on gender. I mean, LGBTQ identifiers, that's just not, for a variety of reasons, whether it would be appropriate or inappropriate, dangerous or not, depending on, the form you're filling out. So, no, so that we don't keep track of that, how many litigants are identified, one way or the other. That's just not something that's being done. The issues, right now, they're concentrated in the probate arena, I think, and that's going to percolate up, and will come to the Supreme Court, as I said, after I am gone. So those are the type of cases that I think need to be watched and seen where they, how they go in the appellate districts. There's a lot of judicial races on the ballot this year, and if you're going to look to the courts for relief, that's where you've got to concentrate. In addition to the legislature, it's important who gets on the court on the ground floor, the trial courts. And the appellate courts, and of course the Supreme Court. That's another area when you're talking to change hearts and minds and get people, to appreciate the problems. It starts with again, I keep coming back to voting, and I just cannot emphasize it enough how important it is. So, the tracking. Let's put it this way, the judge quoted the statistics of, less than 1% for trans and
More than 1%.
1%?
More than 1%.
More than one, yeah, just over the the 1% mark, then that's indicative of the negligible amount of cases that are filed, just because of the size of the community.
Yeah, I follow up with that. I agree with what the Chief Justice said. We do not track, the Supreme Court has all kinds of reporting requirements that trial courts have to report how many cases they had in different categories. It's mainly a way of tracking courts, how quickly they're getting cases wrapped up. Probate court has the same responsibility to report numbers of cases, different types of cases. We're exempt from the time limits that some of the other courts have. When we started doing the gender marker changes, we made a conscious decision in our court not to separately track them. They're lumped in with the groups of birth correction cases. So when I said we get approximately 10 a week, that's just based on my talking to my clerks and say, well, how many do you think we see? We don't want to track them. We don't want anybody to be able to come down to the court. They're all public records. To come down to the court and perhaps have access to files that they would use for nefarious purposes to find out who is out there in the community changing their gender markers. So we don't separately track them, even though they are public.
You know, criminal cases involving LGBTQ clients are sometimes challenging. Do any of you have advice in that arena for criminal attorneys and how they should be handling these cases in this ever-changing landscape, as well as the cultural pushback that they might get when they get into court?
I can make one comment just before I forget. Of course, my court doesn't do criminal cases.
Right.
But when I talk to my friends at the Franklin County Municipal Court about this topic and whatnot, Franklin County has a domestic violence program for victims of domestic violence and the defendants, specifically geared toward the LGBT community, because they have different issues than straight domestic violence victims and defendants. And it seems like it's been a very successful program. I forget what it's called. It has an acronym. But it's interesting that Franklin County Municipal Court has recognized that difference between domestic violence victims in a same-sex relationship and in a different sex relationship, different gender relationship. So it's just interesting how courts are recognizing there can be some differences. That doesn't address your question about practitioners, but I just think it's interesting that the Franklin County Municipal Court in particular has that program and it's very successful.
I think when you have advancements like the Franklin County, Municipal Court, and they have a specialized docket for same-sex partners and domestic abuse, and the recognition that it's much different than hetero couples and their issues, that's real progress. I wonder how many attorneys know about that. That they could advise their clients if that's a situation. As far as an issue with criminal attorneys representing clients, that's what you're talking about. Is that, again, I'm very far removed from whether they're having issues within the court system. I remember when I was a practicing attorney a bazillion years ago, I had a client who was trans, I guess would be, this was back in the 80s, and he had to go to the male jail, and there was just no alternative for that. Even though he identified, looked, acted as female. I don't know that it's any different today. Maybe attorneys in the audience would know, but I don't think it's any different with regards to incarceration today.
Go
I was
ahead.
just going to say, I would note if I can't really advise. I was a civil attorney, so I don't have a lot of criminal experience. But I think it's important to note that transgender women of color are murdered at a rate that is exponentially higher than any other category that there is. That says all that we need to know. And there aren't task force and efforts and things because, again, of the lack of empathy, of care about the transgender community in particular, but specifically transgender women of color. And I think that's where there's opportunity for those, if there are justice-minded criminal attorneys out there where you want to make an impact. That's an opportunity.
I do want to ask you, Raphael and Camilla, from your perspectives, what are the emerging issues in this arena for the LGBTQ community that we should all be aware of? We've been talking a lot about legislation and about the changing cultural pressure on the community. But from your perspective, what you will be working on going forward, what should we be paying attention to?
Well, I think we've touched on a couple of them, a couple of those issues. Now we are the transgender. You asked earlier whether or not we are regressing. My concern, and I won't speak, I don't want to speak for the ACLU, but I think where one of the areas we have to be concerned with, it goes back to the makeup of our judiciary, and that is in turn determined by our electoral process. Because as we have the courts, if we go back to the Stonewall, riots, Matthew Shepard, we can come all the way up through at least my lifetime of where the courts have been, where we've relied on the courts to rescue us from ourselves. And I don't know that is where we're headed now. Seems to be in a very different direction, and that's frightening because we can't turn to the federal courts where we once did. We can't turn to the U.S. Supreme Court or even Congress, because that's we see what's happening there, and that's where those issues, we can't go to those issues that have and fight for those issues because we don't have the representation in those bodies.
Some of these issues, though, were decided on the local level. And as Justice O'Connor pointed out, we have a lot of important elections coming up. So how do you research a judge? Because we all know that people get ballot fatigue. By the time they get to the end of the ballot, they're looking at things like Irish names. And is your name Brown? That's just...
Well, speaking as an Irishman that beat a Brown, I'll tell you that... Okay, judicial votes count.ohio.gov. That is a website that is at the Supreme Court. judicialvotescount.ohio.gov. We beg judges who are running for election to fill out the information. We post it on that website. They can update it as the campaign progresses, as the campaign season progresses, with their endorsements and anything else that they want to put on there. Not a commercial or something like that, but information that'll help the voters. And it's the only website of its kind in the country. And I would encourage you to take a look at it, to encourage other people to take a look at it, to find out about the people who are on the ballot that are running for the judgeships. And that's all the way from your municipal up to, the Chief Justice's position. The munis aren't on the ballot this year, but, in off years, as they call it, they would be. And it's by county, so it's pretty easy to maneuver and find out that information. If somebody doesn't put their information on there, I think it's pretty telling about because this is a nonpartisan website. It does not cater to one party or the other, of course. So that's a true resource. Candidates' nights. Candidates' nights are telling to see who thinks it's important to go to various interest groups that are having candidates' nights. It's important to ask questions. I think, having been to someone who's campaigned in many campaigns over the years, I think it's a great idea not to lump different kind of candidates together for candidates' night. Have a judicial candidates' night. Have a legislative or local, municipal, or county candidates' night, so that you can give the candidates that are there, ample time to make their case, and then you can ask them questions. And that's an important way to get to know. One, you can tell who's interested in the various interest groups, who shows up, and then those that do, you can question them about things that are of interest to you. That's, I think, extremely important. I think it's also important to look at who endorses the candidates, because a lot of times that's code for political philosophy, interest groups that want to see one person or another being elected. And those are all ways that you can garner some information. And as far as ballot fatigue goes, I would encourage people to make decisions before they go into the ballot box, but here's the thing. You don't have to just vote on one day in Ohio. You know, you have weeks to vote. You could have a voting party. You could, you know, if you wanted to have information shared, you know, get a group of people together, have your ballots, go down. Everybody can contribute what they know about that candidate, what they need to know. Okay, you need to know something, let's look it up. Let's see what their website says and share that information. You know, a little wine, a little cheese, a little ballot, you got it going on.
I think it's really good to be drunk when you're voting.
I didn't say drunk, Colleen.
We are the Irish delegates on the stage. Camilla, before I get off track, and I'm going to get each of you to give me some final thoughts, but I do want you to tell me what Lambda is working with right now, what you're really pushing that you want everyone to be aware of.
Well, we're trying to ensure that people have access to health care that they need. We're also facing a situation where anti-LGBT advocates in court are trying to weaponize the First Amendment in order to take down anti-discrimination laws across the country. And you had mentioned earlier the 303 Creative case that's currently before the Supreme Court. These anti-LGBT advocates are trying to argue that the right to free speech is a pass from having to comply with non-discrimination requirements because it would cause them to have to express inclusion and acceptance of LGBT people if they were forced to serve LGBT people in the marketplace on the same terms as other people. So that is, you know, a current landscape that we're litigating around the country. There's also a number of cases involving anti-LGBT teachers who claim that they have a free speech and a free exercise right to misgender trans students in the classroom and to refuse to use the names that these students prefer. That is particularly worrying here, where we're sitting in the Sixth Circuit in light of a recent Sixth Circuit decision that came down. And then there are, you mentioned criminal cases and what should criminal lawyers look out for. There are many contexts in which LGBT people and people living with HIV face heightened penalties in the criminal legal system and discrimination, whether they are sentenced to more time or punished more harshly in other ways for conduct that would not be punished in that way if they were a cisgender straight person or someone who doesn't have HIV. We're still seeing contexts where judges are sentencing people living with HIV more harshly in light of the fact that they engaged in sexual misconduct of some sort, even though they may be completely undetectable and incapable of transmission of HIV. And in the context of advocacy with respect to HIV, we recently won a great victory before a district court holding that the military was engaging in unconstitutional discrimination because it was refusing to allow people living with HIV to commission as officers or to deploy. So that has been struck down nationwide. And finally, there are cases to watch involving government funding of service providers such as child welfare agencies that refuse to serve, say, same-sex foster parents. They refuse to license them, that refuse to recognize that they may have LGBTQ kids in their care. These are exclusively federally funded agencies. They are providing a government service to children who are in government custody, and yet they are engaging in discrimination. So we are litigating those cases in a number of states across the country.
You mentioned education. Ohio had their Teacher of the Year was named the National Teacher of the Year yesterday. He's from Northeast Ohio, and I apologize, I forget the school district, but he teaches African studies and diversity and inclusion. Under the current proposals at the legislature, his curriculum would have to come to an end. Is that a case you would take up? I see you nodding, Raphael. Is that a case that we could see in a court here?
Well, again, I'm not our legal director, who is phenomenal, but those are exactly the types of cases when we say the Constitution is our client. That's what we mean, because simply teaching actual factual history should not cause a national Teacher of the Year to lose their entire curriculum. And that is, so those are, when we think about emerging issues, those are definitely these issues. And you asked earlier, Colleen, part of this, and Camilla mentioned it earlier too, we can't unravel, like the education is connected to LGBTQ, is connected to voting rights. It literally is interconnected, which is why it seems like we have so many irons in the fire, and we do, but they all lead back again to, for as flawed as our country may be, whatever the imperfections, we have a democracy it is miraculous in how it works. But it works because we make it work. It works because we determine that we want it to work. And that's why I am an eternal optimist when it comes to, I will continue to be optimistic that we have the opportunity to change culture, to change thoughts and minds, even in the 88 counties that are some of those 88 counties that are, they're maybe a little rural and probably haven't seen a whole lot of things. There are some opportunities there to simply reach out to our neighbors, talk to them, and educate them about some of the things that are going on in our world.
Well, we are about out of time, and when I'm doing interviews with people, especially when they're political candidates, at the end I always very often ask, what's the one thing you want people to know about you? So I'm going to ask the four of you, what's the one thing in this arena, if you could wave your magic wand, what's the one thing you would like to do to advance these issues for the state of Ohio and make progress in the way you would like to see it? And I'll start with you, Chief Justice.
I think the answer is obvious, but I can't talk about the case.
Well, that summed it up pretty well. That was her minute of time, so let's go to you, Camilla. If you could do something that you could advance, if you could see progress in this arena, what would you like all of us to know?
I certainly can't beat the Chief Justice, so anything that I say will be insufficient. I think it's important to recognize that we can make progress, and we have done so. And in fact, during the darkest days of the Trump administration, when the Trump administration, for example, would pass an executive order that said that you can't mention implicit bias, systemic racism, or critical race theory in any federal contracts or federal grants. It was a group of LGBT centers and LGBT healthcare providers that stood up and challenged that executive order, saying that they had received federal contracts to address COVID receptivity, for example, in communities of color, and they were addressing disparities with respect to HIV. And in order to continue to have trust in the communities that they serve, in order to do this really important healthcare work that they were doing, they needed to be able to address our nation's pernicious history of discrimination in the provision of healthcare and medical research and so on, because unless you name it, you can't solve it. And they stood up in particular because of their history in fighting the HIV epidemic. They understood the cost of silence. And we won. And we stopped that injunction, that executive order, with an injunction. And I think that that same advocacy on behalf of the LGBT community, those brave institutions who risked their entire federal funding, and they did not know at that time whether President Trump would be reelected, is exactly why we succeed. And we can do that. We can do that with curriculum laws. We're about to see, I think in the next few weeks, a second lawsuit challenging Florida's Don't Say Gay. We can continue to win, even in a changed judiciary on the federal level, because there are justices and there are judges with integrity who are standing up to do what's right, and there are advocates and plaintiffs who are willing to take risks to do it, and there are incredibly brave community members who are willing to stand up to be plaintiffs.
Judge Mackey?
I would answer that by kind of stepping back a little bit and say, what is the reason we're here today. This is the Ohio State Bar Foundation Unity Summit. The program says it's the LGBTQ+ education, law, and policy. Education, I'm a little pessimistic about that. Education, you talk about the media, they should be educating us. The media is so siloed now, people only listen to what they want to hear. That's kind of a disheartening prospect. Education on another level, school boards of education. We've all seen this, we talked about that a little bit today. School boards are becoming at the ground level very politicized. It's the interaction between some kind of people who have specific agendas can go to these school board meetings and try to get them to address issues that we would not think are reasonable. So education part of this, I'm a little pessimistic about that. Policy, well, that's a big issue, but policy, I think of, we're here at the state legislature. They make policy in the way of laws. And we've had some reference made to Equality Ohio. Elena Yoakum's here today. The Fairness Act, which has been introduced over 20 years here in the legislature, it has not gone anywhere. So policy, if we're talking about legislative policy, especially here in Ohio, I'm not sure where that's going. And then we have law. So I kind of see the judiciary as kind of the backstop to protect a lot of rights in Ohio based on the U.S. Constitution, the Ohio Constitution, and just statutes. So I wouldn't say we're there as the only bastion of liberty, but we are a backstop to help people, as these two individuals certainly know from the actions they've taken in a lot of times in the federal courts. So education, policy, the law. I'm very optimistic about the law, the judicial branch. So that's where I'm coming from.
And Raphael?
I would say if there was one thing I could do, I would challenge everyone in this room. I believe democracy itself is on the ballot this midterm election, November. I would say to each of you, find 10 people, not 10 people that you live with. Go out and find 10 people to make sure they're registered to vote and that they actually go to the polls and vote. As our Chief Justice mentioned, there is, where we are now, the one thing that I would like to see, because I think it all emanates from who we have as our representatives, is if we have fair districts, that changes, that's a game changer. It changes everything, because then we're not talking about these things. We're talking about how to better education. We're talking about how to retain Ohio talent. We're talking about how to improve healthcare outcomes. We are talking about a whole host of different things that actually affect all of our lives. We're not talking about whether someone who identifies as transgender can be on the swim team, because that's irrelevant, because of course they can be on the swim team. Why wouldn't they be? So that's where I am. That's how and I am an eternal optimist. I believe we can do this, but it takes us to actually leave this room and go out and do something. We can't just have what we've had here. We all are on the same page. Let's go out and find 10 people, each of you, and drag them to the polls. Make sure that they vote, and give them some education before they vote.
Well, I want to thank this panel. I think we all learned how hard the judiciary is working for us, the action the ACLU and Lambda Legal has taken, and that Justice O'Connor is not really a Republican. Thank you all for that, and I'm going to turn it back over to Joseph.
Wow. That's all I can say is wow, that was phenomenal. Thank you all so much. Please let's give them one more round of applause. That was amazing.